So there's lots to be said from the judges, very, very insightful comments and Status's characteristically thoughtful ones. I just want to start with Luciano's point about the unified definition of micro enterprises or small enterprises. We considered this, and after months of thought, we rejected this idea. And we rejected it for the following reason. Why should there be a special treatment of micro and small enterprises in insolvency? We think that's because there are some businesses which are too small to justify the involvement of courts, which would mean the involvement of lawyers as well, and or the involvement of insolvency practitioners, and or the full deployment of the tools of insolvency law, like full automatic stays and so on and so forth. Now, given that that is the reason why we think special treatment is merited for micro and small businesses, it necessarily follows that there can't be one definition across jurisdictions and economies of what is a micro business and what is a small business, for the obvious reason. What is too expensive in one jurisdiction may not be too expensive, like for like, in a different jurisdiction. For example, legal advice in the UK is extremely expensive. Legal advice may not be as expensive in Italy or Spain or what have you. Insolvency practitioners are extremely expensive in one jurisdiction, and they would be less expensive in other jurisdictions. So given business of the same size in different jurisdictions, given that these mechanisms would be of variable expense and variable cost in different economies, it is impossible and inappropriate. Well, it's possible, but it's inappropriate. It defeats the purpose to have the same definition of micro business and small business across the board. Defeats the purpose because, you know, what is appropriate in relation to legal advice being too expensive for this size of business in the UK may be completely inapplicable to Italy, where legal advice is very much accessible. So have court involvement there, given the same size of debtor. So it would be, and the same argument applies in relation to each and every element of the standard insolvency regime that we think is inappropriate to micro and small businesses, and which we think motivates us in suggesting a special regime. So I think it's a very, very ill-advised idea to have. We know that the Commission has proposed, for some purposes, proposed uniform definitions of micro and small and medium enterprises, perhaps micro as well,
yes,
through a combination of one or more of three factors: number of employees, turnover.
It goes all the way to 400 employees, I think.
Yeah, something like that. So we think for some purposes, for reporting purposes, that makes perfect sense. When it comes to insolvency, it would completely defeat the rationale for having a special MISME regime.
Just two minor comments on following up on Riz and then I think on discharge. At least Riz and I, within this group, I don't think anyone else, but definitely Riz and I thought, I'm sorry to say, that this optional approach is fit not only for small and medium enterprises, but for any company. Actually, the bigger the company, the more fit it is. But this is a personal idea. And second, more importantly, in order to provide one of the solutions that are included here in the proposal is an automatic discharge in case no one screams. So, you know, facilitates the discharge so much that unless someone says, well, there's no reason for this guy to be discharged, this guy is going to be discharged. So it's...
I'm just wondering, maybe a thought or question of encouragement. So Michaela said very clearly this morning that there's going to be no kind of new chapter with this modular approach or special approach for SMEs in the directive. But I'm just wondering, have you given thought whether this kind of thinking, these structures, which I think are actually very appealing, could be implemented in national systems without actually violating the directive? In other words, would the current draft of the directive prevent these types of structures being inserted in national legislation? Because otherwise it still makes sense to promote these thoughts and further develop this thinking, and then you know, maybe advance these ideas with the member states?
Absolutely. Absolutely. This is what I said earlier about the fact that, A, let's not give up. Perhaps I mean, Michaela mentioned in the morning that it is more difficult to introduce new provisions, but you can never know. And second, of course, it will not prohibit member states from adopting the modular approach in their legal systems. And this research shows that it is possible to do that even if it is not fully uniform. So you can do it without a directive. A directive will be very, very helpful. It can accelerate that process. It can deal more effectively with SMEs, making sure that member states actually take action. But otherwise, yes.
I haven't tested these thoughts with the directive. I just question, to me it's not self-evident that this kind of structure will be allowed, at least under the current draft of the directive,
so
because the
the
directive prescribes certain court intervention. It prescribes, in the current version, appeal. You know, it does prescribe quite a number of things that might actually conflict with this very light touch idea.
That's a very good point. I think Ondr is the appropriate one to answer that.
Yes.
Come to that in my final remarks, so maybe if there are some final questions, I will come to that question which Nico raised in the closing remarks I prepared. So unless I don't want to interrupt if there are any questions to the topic, so which were
collect more comments, and then we can come back to this important point, because of course this is another incentive for addressing SMEs, or at least excluding them, or allowing some leeway, some flexibility within the directive, so that it will not prohibit additional developments. But let's come back to that. Yeah.
Just a small comment on that issue as well. So thinking countries where the non-performing loan volumes are extremely high, so probably there would be incentive for the financial sector to create kind of easier tools to get mediation type proceedings in place to get these things sorted out. So that there should be also kind of financial sector incentives for the purposes.
No, just a very small point actually. It's a matter of detail. I don't want to overcomplicate what is intended to be a sort of simple and as uncomplicated as possible a process. In relation to the sort of scream or die idea though, have you thought about how you'll deal with creditors that are difficult to locate, or where identification of creditors becomes problematic? Because that obviously, you know, cuts across the sort of advantage of the scheme that you're talking about.
I think I only got the last part, but the answer to that is yes, we only apply scream or die to properly notified creditors. And if I might take a step back to the previous questions, we also take care of that, not in the MSME part, but in the long list of chapters where we provide possible recommendations for amendments also to the directive. One which hasn't been discussed is confirmation. And confirmation, we try to provide some rules for that. And in some cases, a confirmation will be necessary. In others, it could be potential. But in the case of MSMEs, it's coordinated with it. I don't remember exactly, but I will send you what we prescribe for confirmation. And it is, I think if that's implemented in directive, then it will be consistent with the MSME part as well. So it's a whole picture that we provide.
if we're opening up the sort of ground more generally, could I go back to something that was discussed in a previous session about the best interest test? Because this is a test, obviously, which has a lot of value. Yeah. On the best interest test. So I think this has a lot of value, and I absolutely agree that the right approach here is to think about what is the appropriate alternative. So it shouldn't just be one model of valuation, the liquidation valuation, but it should be whatever is the alternative to this particular plan. The difficulty with that, of course, is that who is it that is going to judge what is the alternative? And this is something which has been very problematic in the UK regime, as I'm sure you know, where it's in the interests of the debtors and the senior creditors to argue that liquidation is the only possibility, whereas, you know, because that benefits them both in valuation terms and also holds a gun to the head of the judge in terms of sanctioning the scheme. And we've seen UK judges start to push back on that, but it's not an easy thing for them to do. So it requires a very robust approach from whoever it is that's put in charge, the judiciary or some other body. And that seems to me to be absolutely crucial to a best interest test. And I was just wondering how you thought that would operate in the scheme that you have in mind.
Jenny, thank you very much. I highlighted that this would be where the rubber would hit the road on this proposal. The comparator, identification of the comparator and the valuation in this identified comparator. I think the starting point is to remove the presumption, often effectively irrebuttable in the UK scheme context, that the comparator is always going to be insolvent liquidation. So get rid of that presumption. So the parties have to show to the judge's satisfaction by whatever test is appropriate, more likely than not, real prospect, let's argue about that. But the judge has to be satisfied that if the scheme is not approved and implemented, then this is what happens to the debtor. It may be liquidation. Even as the judge pointed out, liquidation itself is multiply ambiguous. It's ambiguous between the proceeding, which is a formal legal status, and what happens to the debtor and its business. 10% of liquidations in the UK, 10% of proceedings called liquidations in the UK do not result in the breakup and liquidation of the debtor's business. They result in going concern sales of the debtor. So you have to establish by an appropriate, to the appropriate level of proof, more likely than not, or reasonable prospect, that this is the alternative if the scheme doesn't get approved and implemented. So let's start there. I know that in the My Travel case some years back, the court, Mr. Justice Mann, took a very firm view that liquidation was the alternative, and Michael Christen and I were amongst people who challenged him on this. And then in Bluebrook, a few years later, he took a much more circumspect approach. So the UK courts have been pushed in a more enlightened direction, and Mr. Justice Snowden is going to do wonders, I anticipate, on this front to the extent that he can. This is an issue. Get rid of the presumption that the comparator will be insolvent liquidation. Let's start from there.
Yeah, thank you very much. I would like to comment on the discussion with respect to absolute priority rule and best interest tests from perspective of a practitioner's point of view. If you look at the situation, and I followed the discussion, and I thought to myself that maybe a supercomputer could better do the calculation than a human being and a judge. But this being put aside, I think that the best interest test must be simple to calculate and must be foreseeable, because this is the negotiation benchmark that you need in order to convince the minority creditors to accept the plan. that's the first point. So if it's complicated, I'm afraid that it is counterproductive. It must be simple. That's the first principle. The second principle, I think, there is additional value. And the allocation of the additional value among the various classes of creditors is subject to negotiation in my mind. Because if you interfere, and if you would try to say, this must be allocated under some kind of formula, you end up in a nightmare situation, because it must be open to the discussions among the various parties, subject to main principles that, of course, you cannot reverse priorities. So you cannot say, I will reimburse first the subordinate one and then I will reimburse the senior one. That is not possible. And there is the judge. And the judge, in my view, once again, he has a fairness test to apply. And if you regulate too much, I'm afraid that you do not take into consideration the specificities of the various cases. Because in practice, if you look at the French market for the last 10 years, the French system is not ideal at all on this point of view. So it must be changed. But this being said, what I saw in big restructuring cases is there was a lot of dispute about who gets the additional portion of value. And it is impossible to arbitrate this, other than there's a force that people are in the majority and people are in the minority. And once they are in a majority, the minority wins. It takes it all. And there is the principle. And then the judges there and say, you should be a little bit more reasonable. And this is the way that I think it should be handled, with some kind of possibility for the judge to have an exercise its fair judgment rule, so that the judge is not redoing the negotiation. He cannot interfere into the negotiation. He just makes sure that the end result is a fair end result, which is in according to the main principles, and anything else is subject to negotiation. Because otherwise, the draft of the law would be impossible, and the application would also be impossible. So I prefer in the pre-insolvency world to have very simple principles in the law and leave it to the practitioners and to the jurisprudence to decide.
Just
Sorry.
have it.
Stefan, just...
I thought it was about...
If I may. This is my constitutional right to speak. No, just a quick comment there. The basic idea behind, as I see it, behind Reinhardt's idea is not to have some sort of an objective, in some sort of technical, this is 40, this is 20, this is 50 approach, which is nice in theory and in a PhD thesis, but it's absolutely a nightmare in reality. So the idea would be to, at least outside of insolvency proceedings, to have a valuation that is done by parties, and that is also part of the agreement by parties. And if somebody dissents, there is a presumption that the agreed value that came up after a lengthy negotiations with parties is principally assumed to be the correct valuation, unless you have convincing evidence to the contrary. So I think that is a solution that brings negotiation power to the table, and brings a solution that doesn't ask from the judge to know a better valuation than the parties did, unless there is specific evidence for that. The second one is that I wanted to mention earlier is on the absolute priority rule. And I must say that from a principal perspective, both are right. Nico's objection that the extra value created in a plan belongs to the senior creditor maybe is right, as a relative priority rule saying that the extra value doesn't necessarily belong to the priority ladder, but it can be assigned by negotiation. When I did, and Bob has already left, when we did our research with the European Law Institute, we came up with the idea that it depends. If you have, the absolute priority rule is originated in a practice called equity receivership that happened in the US 100 years ago. And it was addressing a specific problem, being that senior credit and equity would act together, sell the business as a going concern, and the capital structure and the equity structure of the new business would only feature senior credit and equity of the old business, and unsecured credit was left behind. And the liquidation value was zero, because no one would buy a railroad or whatever it was. So they did receive nothing, and that was unfair, and the absolute priority rule responded to it, basically saying, unless you pay junior credit even 100%, equity should get nothing. And the basic idea behind it, and I think they're right in that respect, because equity in those big companies doesn't bring anything to the table apart from an investment. And if the investment is lost, the investment is lost. So Nico's case is good. But this is very different when equity is bringing something to the table.
Exactly.
When equity
Which
is bringing
very
something,
often, according to our research.
right, and in cases where equity is bringing something to the table, there is goodwill that is hard to measure. And that is what came up in the discussion. So we have a hard time putting a price tag on goodwill and equity. And I think we also agree, Nico also did, that these are the cases that deserve a different treatment. And I think this is what I already published in 2012, and I think that equity doesn't belong in the ladder then. If there's goodwill on the table, we might have a relative priority rule that is accepting that, but basically it's not about valuation and where the value breaks, but it's that equity is special in that respect, because equity owners are bringing something to the table that is essential for the business. So maybe there is, we wrote that in the report, maybe there's a way forward there.
I think your co-author is gone.
So thank you very much for reference to your co-authored paper with Bob. There's lots of wisdom in there, and I haven't got through all of it yet. I've started. I haven't got to the relevant bit, but I've requested and you've provided the shortcut to the relevant bit, so I'll read it and consider it. So this is in the absence of consideration, so apologies in advance. I agree with Reinhard. Simplicity is key. That's a starting point. Second, to the maximum extent possible, it should be parties who negotiate to the solution. We go to some lengths in chapter 2 of our report, making fun of what we call the God's eye view. The God's eye view is this perspective from which, independent of any weakness inherent in the observer, the truth is perfectly discernible. Does this distressed debtor have viability, or is the viability gone? From the God's eye view, you know without error that that's the case. From the God's eye view, you also know whether equity is bringing something to the table, or whether it's simply claiming to bring something to the table, but actually, as some of our research shows, it's draining away value because it's responsible QA managers for bringing the distress on the debtor in the first place. So, how do you decide that? If we had the God's eye view, or if the judge had the God's eye view, if anybody did, it would be easy. You'd just look at it and you'd see what it was. Given that we don't, even the judges, with great respect, don't have the God's eye view, everything should be left for negotiation. And that's true of the allocation of value. That's true of what value to place on the business in different scenarios. Everything is subject to negotiation in the plan and the perspective that we are proposing. However, guys, we are talking about taking away parties' legal rights in situations where parties have not consented. We are not simply talking about this in situations where the majority of that type of creditor or stakeholder has agreed, so you're just binding a minority. We're talking about by definition, the entire class or a sufficient majority of the class having rejected the plan, and we want to make the plan binding against these people. This is not a joke. So in a rule-governed jurisdiction where you have to have credibility of the market in relation to the process, you have to have some basis for working out whether what is being crammed down the throats of the entire dissenting class is appropriate for them. And in this context, you're not saying there should be stipulation that X euros should be returned or X% should be returned. You're not saying that it should always be a going concern valuation or something like that. You are saying that the court should be satisfied that there is a restructuring surplus, and the only plausible, fair way of satisfying the court that there is a restructuring surplus is by identifying, not with absolute certainty, not from the God's eye view, but from whatever standard we want to agree should be applicable, identifying what would happen in the absence of the plan. In some cases, what would happen would be a liquidation. In liquidation, it may be a piecemeal liquidation or a going concern liquidation. But you have to make some case, you have to establish some basis for saying that there is a surplus because in the absence of the plan, this is what the business is worth. That's all. And everything else is subject to negotiations and subject to the creditors and other stakeholders' consent. So we have to be quite realistic and robust, but let's not throw out the baby with the bathwater. Let's not say simplicity and then sacrifice creditors' rights left, right, and center. Let's hold on to some sensible safeguards.
Status.
Yeah, I think that this is something that is tied to the fact that we want to move restructuring as far upstream as we can. So to the extent that you go with likelihood of insolvency, which may be a very low threshold, and in fact there were recommendations there be no threshold. In those cases, I can imagine that the value of the claim is in fact somewhat greater than the value of the liquidation value of that claim. One idea that crosses my mind would be to say that a dissenting claimant may have the opportunity to show, and it would have to be a high standard of showing, that the value is in fact higher. And in that case, that would establish a threshold. Okay. But not. I think it would be, it would introduce tremendous complexity to allow from the outset for a variety of valuations. But I think we should allow dissenters the opportunity to show that the value of the claim is in fact higher than the liquidation value, and that showing can be made with a high degree of certainty.
Reese, we agree. We agree, because the reality is it is the best interest test which gives you the protection. The question is, how do you allocate the value that has been created by the comparison, absence of plan, by comparison we have a plan, which is better. And the question is, do you necessarily take this value and give it immediately only in accordance to ranking? That's the first problem. And I think it's subject to negotiation and judicial review of fairness. And I think we agree on that. The second point is, and this is something which under German law I don't think is too rigid, because what's happening is, if you have several classes of unsecured creditors who have equal ranking, but you have, for example, you have banks, unsecured banks, you have unsecured suppliers, etc., etc., and you create different classes. In the structuring cases that have been dealing in France, it is obvious that you pay, for example, employees, they are privileged, but you pay suppliers 100%. And the banks are in agreement with this, majority of the banks, because the suppliers are needed. This is an infringement by comparison to the absolute priority rule, which requires normally that all creditors which are in the same class are treated equally. Which I think it doesn't make sense, because economically speaking, you have to factor into the situation that a supplier is more important than an unsecured bank, etc., etc. So you have the utility for the business and the utility, if a majority of creditors agree of a bank side that we should make a sacrifice, and that should unsecured suppliers, which are strategic for the business to go on, should be treated better by comparison to unsecured banking creditors, then let it be. There is no reason why they must be treated in the same way, and that the banks require and should obtain 100% of their unsecured claims, because otherwise it will not happen.
So that's the relative priority rule.
That's it. So the real, in other words, in sum, what is important is the best interest test, and everything else it is according to ranking. So you cannot inverse the ranking. That's for true. That's sure. So you have to make sure that there's no unfair treatment of secured credit by comparison to unsecured, but you should give flexibility to the parties to agree upon allocation of this value, which is in the interest of everybody, which is the interest of the majority of creditors who are supporting the plan, subject to review by a judge.
But what it's worth, while Nico gets the mic, the research supports, at least in some jurisdictions, the idea that the larger the restructuring, the more the parties want basically flexibility, and they want very few rules, and they want to be allowed to reach an agreement because they are repeat players. They know very well how to do things. They know they can't fool one another, and therefore, the more flexible, the more comfortable they feel. So the rules would be more necessary the smaller the business, and that's.
Yeah, well, I just like to observe that I'm very happy to see that we are actually converging to something that is almost fully consensual here. Riz said earlier, came up to me and said, I 99% agree with you, but you know, I'm just here to express my discontent with 1%. So just to add to that level of consensus, and maybe that is the last percent or not, I don't know. We're talking about this surplus that you can realize if the plan comes about. Now, why do you have this measure, which is essentially actually an insolvency measure? You don't do it for the fun of it, right? You do it to increase the pie. That's it. You're increasing the pie. And when you then decide how you distribute that pie, you can't distribute that added value in any fancy way you want, any arbitrary way, just whatever comes into your mind. There are pre-existing rules, and you respect those as a principle to start off with. However, we are all agreed, everyone, at least these 3 years, and I think the rest of us too, that as a starting point, that surplus should be subject to negotiation. And it is a negotiation between the classes. If those classes agree on how to distribute that value, that is fine, and a court should not tinker or mess with that. That is absolutely acceptable. The question that we're talking about here, though, is if no consensus can be agreed amongst the classes on how to distribute that surplus, what do you do then? And in that scenario, I very much agree with Reinhard, where he says, you know, you can't just reverse the existing priority rules. You have existing priority rules that you must respect. In our market, you know, that's sanctity of contract, extremely important, also for financiers. That is your starting point, and it is against that backdrop that you negotiate. You cannot reverse those rules, and you cannot also tinker with them by all of a sudden making them relative or compromising them. They are simply there to be respected as a starting point. Now, the big question I think we can resolve this is what to do with the entrepreneur and equity. Let's distinguish between those two. Those are two very different things. Equity is an old, existing legal right and nothing more than that. It is out of the money, most of the cases. And in those cases where the classes do not agree, it should not receive anything if that is the situation according with its rank. The entrepreneur is something completely different. He is contributing value in the future. And Michael, next to me here, said, you know, it's exactly the same as new money. Although it's not new money that is being injected, it's value that is being contributed in a different form. That is the justification for giving that entrepreneur value, not his old existing rights, which are out of the money. And that is the basis to give him that retained interest. Now, if you look at it from a market perspective, if all of the creditor classes are willing, see that added value, and are willing to give that entrepreneur that interest because they see his added value, it is most probably there, that value. And the court should not interfere. But if the creditor classes do not see that value in that entrepreneur, maybe that entrepreneur does not deliver that value that he sees himself and should not be receiving that interest. So it's very much a function, at the end of the day, of what the classes agree and the market perceives.
Nico, your remarks are very perceptive, and I'm seriously. And I wonder whether you would like to tackle the issue by trying to check what's wrong in point 10 of our proposal, because at the beginning I thought that you were not content with the sentence and more favorable than. So at the beginning of your previous intervention, I said something like significantly more favorable or proportionally more favorable, or am I missing something? With it, yeah. We are on YouTube.
It's very simple. We all agree absolute priority rule is horrendous. Don't go there. That's a bad thing. The only thing I find is it's respecting priority. That's it. And the way that this is formulated here doesn't necessarily respect priority. Why not? Because all it says is that a senior class has to be treated better than a junior class. Now, take for instance the Dutch situation of the Dutch tax authorities. They have to be treated, if the class would dissent, their priority rights would have to be respected, because if the class agrees, fine, we're all agreed. They don't. The whole class dissents. Then my proposition would be, I would submit, their priority rights have to be respected in distributing that extra piece of the pie. Their priority rights are 2 to 1, so they need to get twice as much as unsecured creditors. That is the rule. Now, you could treat them better than the junior class, but it still might be in violation of that rule. It could, for instance, be worse, 1.2 times what the unsecureds get. Well, it's not difficult.
With every example you give, we're drifting away from consensus. It doesn't.
So okay, so we're drifting away from consensus. That's not a bad thing. It's very simple. We have these priority rules. We apply them every single day in our practice. That's not so very difficult. You know, what's the big deal? It's priority rules as we have them. The only thing that becomes difficult is valuation. But the valuation you will have in your system too. So it's just a matter of, do you respect priority, or do you somehow allow priority to be tinkered with?
Asking a very pertinent question. Thank you, Nico. That helps understand your point of view and also helps me articulate why I fundamentally disagree with you. So it's that... No, 99. It's the 1% which is fun to talk about. It's that 1%. Look, what you have just suggested about the pre-restructuring proportion of the entitlements of the dissenting creditors and the junior assenting ones is a reflection of the priorities pre-restructuring and takes no account of the contribution to the restructuring surplus made by those respective classes. And one of the key points about the restructuring plan is precisely how much value is being contributed by different categories of claimant. So what you're saying now is whatever was the case before the debtor became distressed is going to be the ultimate absolute floor for the relative allocations of surplus. But I want to make sure you understand, because you are lightning quick in your mind, but the rest of us mortals need a couple of minutes to get to the point. So I'm just helping them, Nico, not you.
I saw you.
So from that point of view, there is absolutely no justification in distributing the surplus created by the restructuring in a way which is bound ultimately and non-negotiably by the allocation of value before restructuring was required. So your test is entirely backward-looking, and backward-looking as in it doesn't take into account the future contributions post-restructuring to different types of claimant, and I say that's wrong.
So we will continue that discussion, I think, informally, but if we can have a comment from Professor Takagi now, and then from the Commission before we finish.
You don't have the mic.
Okay.
We can't hear you. Okay, Professor Takagi.
As I told you, I came from Japan. When I came to know the draft proposal 2 years ago, it was, I think, this is a very revolutionary thing. And I waited for 2 years, the draft proposal become draft directive become directive.
And now we want to change it.
but not yet. Please, overcoming theoretical difference, please make this draft directive to directive as soon as possible.
Okay, so that's a great, thank you.
This is the very revolutionary, the big influence to all over the world. I am already age of 83, so please, please make this draft directive to directive again within a few years before my passing away.
That will not happen. The passing away. Ondrej, please, please.
That's a challenge. So, ladies and gentlemen, let me do 3 closing remarks on today, what has been said, and also what is about the directive and what is the project. First remark, I'm extremely proud of you, of the team, what it has delivered for the money of the European taxpayers, because this is an example of how the taxpayers' money should be spent. And to those who were on the project, to those who were participating, and as Professor Tagang said, all of us are sort of apostles who are preaching the new revolution, which Mr. Tagang said. And it is an area we have worked 40 years on the insolvency regulation, which is in force, and we are working since 2013, where the recommendation was on this issue. So this is not a work which is closed. This is a work which, in my view, will continue and will blossom and will get wider. So extreme big thanks for what you have delivered and what was discussed. It's not doomed to fail, it's doomed to blossom.
It means a lot to us.
And there I'm coming to the second remark, which is of course the big elephant in the room, which is the proposal of the directive. The text, we are very grateful for your work, of the feedback that we received, and the possibility of changes. I have one good message, and that's in June we had, for those who are not entirely familiar with the nitty-gritty details of the negotiations process in the Council and the Parliament, we have the partial general approach. So at least part of it, Titus 3, 4, 5, so the second chance, the functioning of the insolvency system, so the judiciary and the insolvency practitioners and the data collection is being agreed upon, and principle should not be touched until possibly the very end, where there would be the final compromise. And it's also a big thank to you for the data we have, because although we have discussed a vast amount of data, there is very little of empirical evidence which is based on real case scenarios and real case data, which could guide us in the way not only in drafting the directive, but to do more on insolvency in general. So we have the partial general approach. We now hope that by October we'll try to reach the agreement on the most difficult part, that's the Title II, that's restructuring, and of course Title I, which are the definitions and then the scope. And the process has 2 dynamics. First is politics, which governs everything, and we, at least we in the commissions, are under a pressure to deliver. and which means we'll have to make certain compromises. We'll have to step down on certain things because we want to have it as soon as possible. It's probably not worth from us to insisting on every detail and discuss this for the 5 years, but to have something now with the view that this can be worked on, developed, enhanced, widened in the future, because this is a big construction site. The second constraint is, of course, the negotiation process, because as you discuss with member states certain things, you are basically reducing the option to find the agreement on the smallest common denominator, which means that adding new things, however improve, or what kind, no matter how big improvement they can bring, can partly derail the process, or either delaying it or engaging in discussion which can lead to nowhere. So the closing remark number 2, it's necessary also to have a good strategy, and probably not to propose and try to put everything into the game, but knowing what to put now in order to have an early agreement and save something for the future, because, and that's my third remark, there will be future after the draft directive. There is a big pressure from the ministries of finance when they come. We need to deal with non-performing loans. What do we do? Restructuring, insolvency, and that's good. There is a pressure that the commission looks at it and delivers something also maybe outside the pure area of the scope of the directive and restructuring. Ministries of finance would like us to look on other issues to deal with it at the EU level. So. And that's also an appeal to you. It's now from, let's say, now until the end of the year, when the Commission will be preparing the working plans for the next year, which then will be working plans for the next Commission. It's a possibility to die or scream, because if now all of us scream that we need and we have, this makes sense and it's useful to work on it, the next Commission will work on it. If there will be no screaming, there will be other issues where they will scream more, and they will get the money, they will get the posts, they will get the resources to deal with that. So the last thing is this is not something which will be forgotten, but it will be definitely brought into the process, which I think is on a good path, which has its dynamics, and its dynamic will grow, in my view, instead of being more limited or being restricted, because there is a push from all the players to continue to work on this. And one very last thing, I hope that the know-how which we got, and it's an enormous one, we will be able to communicate also to the players who are currently in the process of negotiating the directive. You know, the European Parliament has adopted its report 2 days ago. We're still trying to figure out what they have adopted, because the compromise amendments were quite messy. So a pressure also from you on the national ministers and the European Parliament also to close down the negotiation as soon as possible is important, and by that you can contribute to having this directive as soon as possible. So Mr. Takeda can read not the draft proposal, but also adopted directive. And as our legal service often says, usually something which the Commission proposed rarely gets better in the negotiation process. So I hope we'll get at least at the sufficient quality at the end when this is adopted. And we from the Commission definitely would like to see it adopted before this Parliament goes to the election, and before there is a new Commission, because that's another element of uncertainty which we can. So Thank you very much again, and please continue this work also in the future.
A few words. Thank you for having stayed until the very end, and thank you to all the speakers: Americo Carol, Andrea Ciocan, Alexander Klauser, Stefan Madaus, Irit Mevorach, Stathis Potamitis, Nicola Tollenaar, and Jean-Luc Valland. And thank you particularly to Ondr, Vondra and Michaela. We want to remark that the research involved 4 jurisdictions totaling 250 million of European citizens, which is a significant part of the European Union. We received inputs by the speakers to further 6 countries, totaling another 130 million people, which is not to say that we have done research on them, on these countries, but at least we got some feedback. It's important to us. We have your emails, and we will send you the final materials if you are interested, unless you want to opt out, and we will keep for 3-4 months, for 3 further months, your emails. Thank you very much, and thank you to my fellow team leaders and researchers, which are in total, I think, something more than 20 people. Thank you very much, and see you soon.